Good morning or afternoon, depending on where you're at. My name is Jennifer Zamarippa, and I'm an attorney at the law firm of Turner Zamarippa Attorneys at Law. We specialize in family law cases as well as juvenile cases, representing children as either the child legal representative or guardian ad litem to the children in our firm that we have here. The presentation of what I will be presenting to you today will be regarding how to modify your child custody orders and how to do that as a pro se individual representing yourself. So I put together a PowerPoint presentation that lays out all of the information regarding how can I change my custody, parenting time, or child support orders. One of the things that you need to know as far as changing any of your child support, child custody, or decision-making orders, that it all starts with you have to file a motion with the court. Luckily for the courts, all of the forms that the courts have are numbered by what's called JDF, so judicial form, and a certain number. Almost all of the JDF forms that we're going to have referring to family law cases are in the 1400s. So 1415, 1407, as you'll see here. But so the first part that you have to figure out is which form you need to figure out. The best way to go and find the forms is literally Google Colorado Judicial Forms. It will take you directly to the Colorado Judicial Forms page that you can search either by judicial form number. You can also search by topics. So if you go into family law, then you can click on all family law forms, or you can look at divorce forms or protection order forms or motions to relocate and all of these things. So the first question that you're going to have is what are you trying to change? If you're trying to change decision making, which is who gets to make the decisions about what happens with the child, you're going to start with JDF 1415. If you're looking to relocate, and we'll talk about what relocation is, but that means you're going to move into a place that is going to change the geographic location in such a state that it's going to affect the parenting time. So if you're going to move to Denver or Colorado Springs, and so the 50-50 custody that you have right now isn't going to work, you have to have permission from the court for the child to be able to relocate. The court cannot tell you that you can't move to a different city, but the court can tell you you're not allowed to take your kid with you to maintain the parenting plan. So you need to ask permission from the court to relocate if it's going to change the parenting time. The most common ones that we're going to see are JDF 1424, motion to modify parenting time. If there's an emergency that pops up that you need to restrict a parent's parenting time because of safety issues, you're going to fill out the same form, but you're going to check different boxes on restricting that parent's parenting time. There are additional documents that we'll talk about as far as a motion to modify child support in the JDF 1403. And most of the time that you're going to be modifying any of these, you're going to most likely want to provide the court as well as the other party with the JDF 1113. That's a parenting plan. It lays out what you're asking the court to order. How many overnights does the child have with mom? How many overnights does the child have with dad? Or if there's another third party or things like that, that will lay out step by step everything that the court gets to look at. After you have filed a motion with the court, you will get what's called a case management order from the court. What it will be that you also have to serve to the other party is it is a case management order explaining what is the procedure now. It'll tell you the deadlines for them to file a response. It'll tell you how to contact the mediation office. If we're doing any types of motion to modify the parenting plan orders, you're going to have to take a parenting class and watch what's called a split video. In that case management order is going to tell you, as well as the other party, how to schedule that video visit for the split video, as well as what you can do about that required parenting class for any disputed parenting issues. If you've already taken the parenting class, I would cover my bases and provide the certificate to the court saying that you've already taken it. The court can then decide if it wants you to take it again, but you will have to take a parenting class and watch this video in order for the court to modify your parenting time. Then once that motion has been filed and you get the case management order, you are required to serve the other party. Regarding service of basically every family law modification that we have that we're talking about today, service can be accomplished by mailing the document and the pleading, is what it's called, the motion, and the case management order to the last known address of that person. Where you're getting into personal service is you have to personally serve an individual for the first time that you start the allocation of parental responsibilities or a divorce. But so what we're talking about today is just modifying what is already in place. But so if you're starting it from the beginning and you're watching this to kind of figure out how the rest of the process goes, and this is helpful in that process, you're going to have different kind of service and personal service necessary for that type of case. The other party then has 21 days to respond if they live and are served in Colorado. They have 35 days to respond if they're served or live outside of Colorado. The courts in Pueblo and our jurisdiction will order mediation between the parties unless either party can assert that there is such a reason that mediation would not be appropriate. And mostly the only time that the court is going to say that mediation is not required is if there's a history of domestic violence between the parties, because there's the theory that the power and the control is going to take over in the mediation. And so not to mediate would be a basis of domestic violence. Outside of a prevalent history of domestic violence, almost always the court is going to order the parties to mediate, unless it's very clear to the court that mediation is not going to resolve the issues and it would just be a waste of time and money for the parties. Even if you think that you guys are so far apart, you'd be surprised at how one or two little things you guys can meet in the middle on a mediation. So almost definitely the court is going to order you to mediation. So be prepared for that. If you do not get everything resolved at mediation, which is fine, you don't have to. If you get everything resolved at mediation, great. But if you don't, then the court is going to set what's called a permanent orders hearing. What the courts are doing right now virtually is we have our setting dockets where you're appearing on WebEx, and then we set the permanent orders hearing date. What we used to do after mediation is we would have what's called a walkover, where everybody would walk to the courtroom and then you'd pick your next court date, but we don't have that now. So you would get put on the setting docket and appear by WebEx for the next court date. Regarding the outline of what we're going to have today is we're going to talk about the types of modification that you have. Why would you modify the court's orders, the types of motions to the court, and then some different things to consider as you're doing this. The types of modification that we have outside of the child support modification that we'll talk about is first and foremost parenting time, which is how many you have, the holiday schedule, the school schedule, the vacation schedule. Parenting time is just the time. The other type of consideration is decision making. Who gets to decide major medical? Who gets to decide education? Who gets to decide religion, or any extracurricular events? It is important to keep in mind that Colorado presumes parenting time should be at 50-50, and Colorado presumes that decision-making should be joint. Those are what we call rebuttable presumptions, so you can present evidence to the court why the court should do something different, but the court is always going to start as a presumption of 50-50 and joint decision-making. Regarding the parenting time, a lot of people talk about that as custody. Colorado technically does not have custody. We have what's called parenting time. The parenting time is based only on the overnights of each parent. That's how child support is calculated, and that's how the parenting time is calculated, is based on the overnight with each parent. As you'll see in the parenting plan that we talked about, the 1113 has the it'll talk about school schedule, so what their normal school schedule is, what it'll change in the summer, and then it will lay out all the holiday schedules as well. You have to address the exchange details in your requests and in your modification of who's going to pick up the child or drop off the child. What I find with the courts, and what my preference is as a practicing attorney, is I usually say the receiving parent is to pick up. So if it's your time with your kid, you go pick up your kid, and if it's their time with their kid, they pick up the kid. So my common one is receiving parent pickup. You're going to address in there the travel plans, vacation plans, access to telephone. There's some written things that are in the parenting plan that talks about parents should have reasonable telephone access with the children during their normal waking hours. So parents are allowed to talk to their kids on the phone and have that type of access. It's going to ask in the parenting time if you intend to relocate. You're going to have to address the child support issues, but it's also very important to know when you file a motion to modify parenting time, the court cannot and will not modify child support unless you file the motion for child support at the same time. And in fact, there's one of the last things that you fill out when you're signing the motion to modify parenting time. You have to initial saying, I understand the court will not modify child support unless I file a motion to modify child support with this. It'll talk about any other expenses that you have for the children, things that you would split, and then who gets to take the tax exemptions and the deductions for the child. So that's really where you're going to want to look at that parenting plan that I had already talked about. What the court is required to consider when changing or modifying any of the parenting plan is the best interest of the child. In determining the best interest of the child for the purposes of parenting time, here's a list of stuff that the court has to consider. The kid's wishes, if they're old enough to articulate what they want, how they interact with family and other members. Is there any history of domestic violence? Some of the things that the courts are really going to be hyper-focused on, most importantly, is the ability of the parties to encourage the sharing of love, affection, and conduct between the child and the other party, as well as the ability of each party to place the needs of a child above their own. So in any type of modification or child custody, it's always about the kid. It's not about mom. It's not about dad. It's what is best for the child, not taking into consideration what mom or dad may feel is fair to them or what they deserve. It's about what that child deserves. So it's always about the best interest of the child. Regarding decision-making is who gets to make those decisions. The major areas that I talked about: medical, educational, religious, and extracurricular. And as I've said, there's that presumption of joint decision-making. Again, well, you'll see if there's a history of domestic violence or just very clear inability for the parties to be able to communicate and to agree on anything. It's very hard to get sole decision-making. So you have a pretty high burden to prove about why you should be the one that gets to make all of the decisions at the end of the day. Some of the standard terms that are in almost all of our parenting agreements and all of our orders is that regarding decision making, that each party needs to understand day-to-day decisions are left to the individual who has the children at that time. That you will have to tell the other party of any changes of your address or phone number in advance, that you have to provide all names, addresses, telephone numbers of any medical, dental, or mental health care providers. Either party can authorize emergency care because, of course, it's an emergency. But if possible, both parties will try to contact the other party first. And any major medical decision will most likely be ordered to be joint decision making. So you're going to have to consult on any major medical decision outside of an emergency care. The other thing to always keep in mind and to refer to in the statutes, Colorado Revised Statute 1410 123.8 talks about every parent is granted and given access to the records of their children, school, medical, dental, mental health records, unless a court has specifically ordered that you as a parent do not get those. It's very unlikely that you're going to have those kind of orders that come out. So if you're trying to access information for your child's school, to get on their, Schoolology or the different portals that they have, if the school's telling you you can't have access to that, you're going to want to start with the 1410 123.8. The school has to give you access to that unless someone else has provided a court order saying that you're not allowed to have that. One of the things that the parenting plans will lay out is they'll talk about for the purpose of school attendance only, what the address is going to be. And that is literally for school only. So you can have 100% 50-50 parenting time, and one person lives in Pueblo West and the other one lives, in Belmont. And you guys are going to have to decide which school area is going to be that kid's home school. And so you're going to list an address only for the purposes of school. And if you choose you want to do District 70, then you're going to list that Pueblo West address. If you decide you want to do Pueblo City Schools, you'll list that Belmont address. So don't get offended or freak out if they're listing an address for the purposes of school only. The schools have to find who the home school is going to be. So that has to be addressed in the parenting plan. Regarding factors for the court to consider when deciding decision making, it determining the best interest of the child for purposes of allocating decision making, the court shall consider these various factors, and that's credible evidence of the party's ability to cooperate and make decisions jointly. Whether there is a past pattern of involvement of the parties with the child that reflects a system of values, time commitment, and mutual support that would indicate an ability as mutual decision makers to provide a positive and nurturing relationship with that child. And whether an allocation of mutual decision making responsibility on any one or any number of issues will, will promote more frequent and continuing contact between the child and each one of the parties. So one of the things that you should be asking yourself at this point in time is, why do I want to modify my previous court orders? In order to modify, you have to have some type of change in circumstance, whether it be a relocation, or we're going to talk about some restrictions that you have that would modify that. In the change in circumstances, you cannot modify a previous court order regarding custody and parenting time and decision making of the child within 2 years from the last modification, unless the child's present environment may endanger their physical health or significantly impair their emotional development. And that's what we're really going to focus on when we're talking about the motions for restriction, is what we're talking about, that safety and health issue. Relocation is what I talked about in changing that geographical location, that it's going to affect the parenting time, that the previous court ordered parenting time is not going to be viable based on this move. So what the court has to consider when deciding if it's going to allow the child to relocate is there a history of domestic violence? Why you as the party want to relocate with the child? Why is the other party against you relocating with the child? Is there a history of quality of each party's relationship with the child since any previous parenting time orders? The courts are going to look at educational opportunities for the child at the existing location versus at the new one. The presence or absence of extended family members, any advantages of the child remaining with a primary caregiver, the anticipated impact on the child for the move, and whether the court will be able to fashion a reasonable parenting time schedule if the change request is permitted, and then any other relevant factors that go to the best interest of the child that we had talked about previously for relocation. One of the things I'll put in as a caveat that I've seen and many times that we're dealing with relocation is if one parent wants to move to a different state, and we're usually talking about they are given a career changing opportunity, a phenomenal job that means that they should go. What you're going to commonly see with courts is they're going to, and that's where those school schedule versus summer schedules really come in. The court's going to decide where that child should be for school, whether it's with the parent who's relocating, and so that parent has the majority of the school time, and then you'll see it flip almost completely for the summertime, that the other parent will have almost the entire summer since they get to miss out on the school time, since the geographical barriers are so big and you can't do so much back and forth. So that's where you really see that breakdown in school time versus summer schedule that you'll utilize regarding some of those relocation pieces. As far as the procedure on a relocation, the party who is intending to relocate with the child to a residence that substantially changes the geographical ties has to file the motion to relocate, and that's JDF 1407. And you also have to file the parenting plan on what you're proposing the court to do. A court hearing on any modification regarding relocation has to be given priority on the docket, so you'll get in there faster than you would on a normal modification. But here is the thing that I will tell you as far as practice and procedure. You need to have basically everything planned out of where your job is going to be. Obviously, you're not going to have a lease signed yet on where you're going to live, but you need to know where you're going to live. You need to know where your kid is going to go to school. The courts aren't just going to say, "Oh, we're going to let you move to New York City, and we're sure you'll figure it out when you get there." Court is not going to allow that. The court will say you get to move to New York City once you get established and a job and a home, and here's where your things are going to be. Then you can file a motion to relocate your child out there. But you need to have almost everything completely in place to where you're accepting that job or you're signing those leases as soon as the court says that you can go with or without the child. But you also need to be prepared because a court is almost inevitably going to ask you, if I decide that the child cannot relocate, are you still going to go? Because that's going to be very indicative to the court about what your reasons for leaving are and what's going to happen. And sometimes that'll play out in your benefit, and sometimes it won't. But be prepared that the court will ask you, are you prepared to continue leaving, even if the court says you can't take your child? Speaking about a restriction in parenting time, restriction talks about that the child's present environment endangers the child's physical health or significantly impairs the child's emotional development, and here's the piece, and the harm likely to be caused by a change of environment is outweighed by the advantage of a change to the child. When you have a motion to restrict, you're really talking about massive safety and health welfare issues. If the court reviews on the face of your motion to restrict that it believes, essentially in the light most favorable to you, that everything that you're saying is true, then the court shall restrict the parenting time, and the court has to hear the case, shall be heard and ruled on no later than 14 days. So if you file the motion to restrict, the court believes that there's enough to restrict, you will have a hearing in front of the court within 14 days where you have to put on all of your evidence why that restriction should continue. And so you'll have to have the witnesses come in and testify for that hearing. Then the court third party deemed suitable by the court or by a licensed mental health professional. So because restrictions can be pretty, very restricting, obviously, that's why the court fast track hearing with 14 days. Oftentimes what'll happen, so you'll need to be prepared, and maybe give work the heads up. If you file a motion to restrict, you're going to get an order from the court, if it grants it, saying, I do find on the face that this motion is appropriate, motion to restrict is granted, here is your court date. The court's not going to call you in and be like, hey, let's get these schedules working. They'll just say, this is the time that the court will hear this case, be ready. So we as lawyers and practitioners, sometimes we've got to juggle and move cases around to get all those things going. But we do know that that's one of the things that we've got to be ready for, is that 14-day hearing, and it just gets set. So you need to be ready for that too. Based on very specific crimes. If a parent has been convicted of any of the specific crimes that are listed there, and the underlying basis is domestic violence that constitutes a potential threat or endangerment of the child, then the other parent may file the motion to restrict, and it shall be restricted. The other parent can then file an objection to the restriction with the court, and again, you're going to have the offending parent. If the offending parent fails to respond within those 21 days, the parenting time rights of such parent shall be suspended until further order of the court. So once you have a conviction of some of these things that get listed in the specific crimes, it's an automatic restriction that it doesn't attach necessarily those 14 days. If that parent does object to the restriction, then the hearing has to be held within 35 days of the response. And so that's based on a conviction. So it's not just somebody saying there is a conviction in a court of law, which means it has been proven, either pled guilty or proven beyond a reasonable doubt that this specific crime occurred. Now, these crimes, so hard to see, but I'm actually kind of happy that we're doing this virtually instead of in the courtrooms where we do this, because trying to put this list together is so hard for people to see when it's just on a big gigantic screen behind me and going through it. But what you're going to see in these are sexual assaults, child abuse, murder, things that child prostitution, pimping a child, soliciting for child prostitution, sexual exploitation of children, a lot of times, if you've got somebody that has been convicted of these crimes, there's probably been a restriction beforehand when they were first filed as the charges. But also know that if you get a conviction during the pendency of any of this, that this can be a restriction that goes into place as well. Some of the things that you want to consider when you're trying to modify current court orders, or again, as I said, if you're reading or watching this as starting from the beginning, this is something to also keep in mind and consider as you're going through the process itself of the allocation of parental responsibilities or the things that the court considers in those parental responsibilities for the divorce. We're going to talk about some advocates for the children. Keep in mind that the court shall not consider conduct of a party that does not affect that party's relationship with the child. The common thing that I can say is someone can be the whore of Babylon. If it's not affecting the way they parent their kid, they're still going to get 50-50 custody of their kid. So the court is only going to look at the conduct that affects that party's ability and to parent and their relationship with the child. In determining parenting time or decision-making responsibilities, the court shall not presume that any person is better able to serve the best interests of the child because of that person's sex. So we have a very clear statute that lays out that, mom isn't a better parent just because she's mom, or vice versa. That it not one parent just automatically gets the upper footing because of their gender or their sex. So talking about advocates for children. We have a lot of different advocates that we can talk about. You're going to want to look for application of payment for some of these costs in a JDF 208. And that means that you can ask the court to find that you were indigent for the purposes of paying for some of these advocates, not all of them. And then the court has to look at the financial guidelines to see if you qualify, and then possibly your fees for these advocates can be paid for by the state. So we're going to talk about a child legal representative, commonly called a CLR, a child and family investigator, a CFI, a parental responsibilities evaluator, a PRE, or a decision maker or parenting coordinator. And so usually the decision maker and parenting coordinator are very similar. And so we will refer to them, or you may hear us say PCDM. That's the parenting coordinator / decision maker. What a child legal representative does. First and foremost, they have to be an attorney who's in good standing to be a CLR. They are appointed to represent the best interest of the child. The CLR may not be called as a witness. They shall ascertain and consider the wishes of the child, but they don't have to agree to it. So they're an independent investigator, and everything that they come across in their investigation, that information is not confidential. They utilize hearsay in making their recommendations. Almost always the court order says that they shall not write a report, so you're not going to get a written report from a CLR. And if you are asking the court to appoint a CLR, you're going to fill out JDF 1319. I am a CLR here in Pueblo. All CLRs in the state of Colorado are contracted through the Office of Child Representative in Denver. And one of the examples that I give parents and kids on what my role is as the CLR is I have to represent what the wishes of the child are. They're old enough to tell me, but I don't have to advocate for them. So I always use my Mars example. If Johnny tells me I want to go live on Mars, I 100% have an affirmative obligation to say, Judge, Johnny wants to go live on Mars. I don't think that living on Mars is in Johnny's best interest because there's no oxygen there, there's no colonies there. Johnny's going to die if he goes to live on Mars. But Judge, you need to know he wants to go live on Mars. Here's what I think is in Johnny's best interest. So where a lot of that comes in is depending on the age and the maturity of the child, we will commonly see kids saying that they want to live with a specific parent who doesn't have a bedtime, who gets a lot of fast food, who, is the Disneyland parent. Everything's a good time. They don't get in trouble or they don't get grounded. And so that's part of what the CLR is going to look at Judge, Johnny wants to go live with dad. Or mom. And the reason Johnny wants to live with mom or dad is because there's an Xbox there that's in their room and they don't have a bedtime. And, dad doesn't make them log in for school, or mom, whatever it may be. And so I have to tell the court, this is what Johnny wants, but here's why I think this is what's best. So that's why the the CLR is an independent investigator for what's in the best interest of the child. The child and family investigator, known as the CFI, they come in under 1410 116.5. They are appointed by the court. It can be an attorney, it can be a mental health professional, or any other individual with the appropriate training, qualifications, and independent perspective acceptable to the court. If you Google Colorado CFI list, you'll come up with a list for each jurisdiction that has a list of all the CFIs that are available in that jurisdiction. Pueblo's is actually very large, but most of the providers that are on there are from Springs and Denver. But you can go through and you can check out their websites, vet them, and figure out who you might want as a CFI. The CFI for the court shall investigate, report, and make recommendations specifically as directed by the court, and taking into consideration all relevant factors for determining the best interest of the child. They have to make an independent and informed recommendations. They are required to file a written report with the court. Usually the court orders that that written report be provided at least 21 days in advance of any substantive hearing. They have to list and ascertain the child's best wishes. Similarly, they do not have to agree with what the child wants. And the CFI may be called as a witness. And if they are called as a witness, you will want to get what they call their CV, curriculum vitae, because your child and family investigator would testify as an expert. That's how they get to say, this is what the child told me. This is what somebody told me. They're allowed to consider those hearsay statements on why they're making their recommendations. I will also note, depending on the judge, some judges believe that the CFI report automatically comes in a hearing, and some judges do not believe that. So you'll want to clarify from your judge if they believe that they are allowed to review the CFI's report at the hearing if the CFI does not testify, because at least one judge thinks the CFI must testify saying, I wrote this report, and then the report gets to come in. We also have what's called a parental responsibilities evaluator. Each one of these gets more in-depth, more individualized. Each one of these are more expensive as you go, CLR, CFI, PRE. The court may order any county or district social services department or a licensed mental health professional qualified to write a written report concerning the disputes regarding the allocation of parental responsibilities. The court shall consider whether an investigation by a CFI or CLR would be sufficient, but if they're not, the court can just order the parental responsibilities evaluator. This person will be sending a report or evaluation, and supervising its preparation shall be a licensed mental health professional. The mental health professional may have associates or persons working for them or under them, but again, your PRE you're going to call as a witness to have them testify to why they put what they wanted to in their report. And the PRE will also write a report for the court, usually provided 21 days in advance. The court can consider a decision maker, but the court does not have the ability to order a decision maker if it's not necessarily agreed on by the parties. So the court can appoint a parenting coordinator, whether the parties agree or not. But in addition to the appointment of the parenting coordinator or an arbitrator, the court at any time after the entry of an order concerning parental responsibilities and upon written consent of both parties, the court can then appoint a qualified domestic relations decision maker. What the decision maker would do is they hear the disputes between the parties, and if they can't agree on something, they get to hear both sides of it. Each party has to pay the decision maker privately, and then the decision maker gets to make the final decision. So when you get a court-ordered decision maker, you're not constantly going back to the court for the judge to make all the decisions. You've hired a professional to come in and essentially arbitrate or mediate and make the final decision of what's going to happen on any of those disputed parental decisions. A parenting coordinator is very similar in the fact of what the decision maker has, but they're not allowed to make the final decision like a decision maker does, which is why, because the decision maker's decision is binding, it requires the consent of both parties. In order to modify child support, you have to fill out the paperwork for the modification of child support. So look at your general considerations, income, and the forms that we have. Keep in mind that child support is completely separate from any allocation of parental responsibilities. I tell my clients, and courts will tell people all the time, the numbers are what the numbers are what the numbers are. The court very, very rarely can, in very, very rare circumstances, deviate from the outline and the formula that comes out for child support. If there is child support enforcement in place, or if one of the parties is getting certain benefits from the Department of Social Services or Department of Human Services, the department may intervene and take a position on what the child support order should be. Now, the purpose of child support is to calculate support based on the parents' combined adjusted gross income. So essentially, the idea is, what amount of money would the child have available to it if the parents were still together? The child doesn't get to be punished because the parents separated. So if mom makes $5,000 and dad makes $5,000, then the combined adjusted gross income is $10,000, and then that's how you start dividing things. The court will adjust child support based on the needs of the children regarding some extraordinary medical expenses, childcare costs, and overall what the court is looking at on the child support amount is overnights. So the amount of child support to be paid by each parent is based on the parental care arrangement. So those overnights that we were talking about on how you calculate those. Child support will be paid until the child is 19 years old. Unless there are other agreements by the parties. You can't agree to stop child support prior to 19 years old without the court's approval and order. But there are times that you can agree to continue child support or extracurricular and post-secondary education. It's not very common that we see that, but you can agree to those things after the age of 19. The child support orders will also look at the dependency exemptions and claiming. Unless otherwise agreed parties, the court shall allocate the right of the parent to claim the dependent children, essentially based on in proportion to their combined income. So if dad makes 75% of the combined income and mom makes 25% of the income, even if dad has 0 overnights, dad will be able to claim that child 3 out of the 4 years. Because the idea on the exemption regarding that child support amount is whoever is going to get the biggest benefit from claiming that child on taxes is who should be claiming that child more often. The other piece to consider in that is that if a parent who has a child support obligation is not current on their annual child support obligation, they cannot claim the child. And that is only based on 1 year. So from January 1st to December 31st, if every cent of child support has been paid that year, then that parent gets to claim the child for the exemption and tax purposes. They could have arrears from 5 years ago that they're still paying off, but the exemption is going to be based on that 1 calendar year of January 1st to December 31st. In order to modify your child support orders, you're going to have a change in circumstances that amounts to a 10% increase or decrease in the current child support order. So if you go online, there is an online in the forms page where you can type in what your gross income is, as well as you can type in what the gross income is of the other party, any costs for child insurance, extraordinary care, things along those lines, and then get an idea of what the child support order should be. Now, courts have to look at your gross income. So one of the things that I try to advise clients about gross income is that's the gross before your taxes are taken out. And if you get paid every other week, you don't get paid twice a month, because some months you get paid 3 times that month. So if you get paid every other week, what you're going to do is you're going to take your hourly rate times what your hourly hours are. If it's 40 hours, so your hourly rate times 40 hours, multiply that by 52, because there's 52 weeks in a year. Then you're going to divide that by 12. That is your annual or your monthly gross salary. If you are actually paid on the 1st and the 15th of every month, then you can list you get paid twice a month, and here's the amounts. But you'll fill that out on your sworn financial statement. Lots of things are included in income, and some things are not. Overtime for that is not mandatory by your job is not included in income. Additional jobs. So if you go out and get a second job at a retail store, that additional income is not included as income for child support purposes for anything that's over your original 40 hours a week at your primary job. Court can't consider Social Security benefits received by the minor children or on behalf of the minor children. And earnings or gains on a retirement account or IRA. Those types of things are not income. Considerations about income is that if a parent is voluntarily unemployed or underemployed, child support shall be calculated based on a determination of that potential income. The way that the court looks at if somebody is underemployed or unemployed is if the employment is temporary or is reasonably intended to result in a higher income within the foreseeable future. That the employment is a good faith career choice that is not intended to deprive a child of support and does not unreasonably reduce the child support available to the child. Or the court will say that they're not underemployed if the parent is enrolled in an educational program that is reasonably intended to result in a degree or certification within a reasonable period of time, and that will result in higher income, so long as the educational program is a good faith career choice and it's not intended to deprive the child of support. Some of the things that the courts will look at to adjust income is if the party has any other children not of that relationship. Daycare costs for children under the age of 12. The child's portion for premiums of health, dental, or vision insurance. Any extraordinary medical expenses for the child, or any other extraordinary expenses to the child. The court is not required to, on those extraordinary other expenses, to do it as an offset on the child support, but if you can document what it is and that it's a continuing expense, then the court may consider that as well as an adjustment to the income. The necessary forms that you have to modify your child support is the verified motion to modify, the 1403. If there's a stipulation on the modification, you can enter into that. You have to provide a proposed order to the court. You are required to provide a sworn financial statement, which lays out your income and the information and assets and expenses that you have. You'll have to do a certificate of compliance under the 1104. You have to provide a support order, and you are required to provide the support worksheet. The software for calculating that support worksheet and printing it up is based on guidelines that you can get at the self-help forms on Judicial's website. You'll Google Colorado Judicial Forms. It'll take you to the self-help and forms. You're going to go under all forms and instructions, look under divorce, family matters, and civil unions, and then there'll be a link there that will calculate child support or maintenance, and it's located under the custody and child support section on that piece. If you have any questions about how to modify your parenting time or your child support, the Self-Help Center is always ready and willing to help you guys. They have a great staff there that makes themselves available, but they cannot give any type of legal advice. They can't tell you what you should do or shouldn't do. They can provide you with access to the forms and answer some basic questions, but keep in mind they cannot give you any legal advice, but they can assist you in that fashion. So if you have questions, make sure you contact the Self-Help Center at the local judicial building. And that is our presentation on how to modify the child support as well as modify any type of parenting plan that is currently in place. Thank you guys and have a nice day.